Very good evening, my dear friends. And last week we have covered about the basic history, historical development, and derivative that the word banking has come from the bankers and then bench. This particular aspect we have covered in the last week. And then I told you historically the banking system developed in 2000 BC, and the Babylonians stated to have developed this particular banking system. The practice was that the people used to deposit their money and valuables in the temples. The Romans and Mohammedans prohibited charging of interest on money that was borrowed, treating it as a sin. Then, friends, in India, the banking system was developed in the form of depositing of money and also pledge of valuables. Banking basically is connected with that, and it goes back to Smriti period, as I told you, and subsequently in Vedic period also. You find the reference to Manu Smriti and Kautilya's Arthashastra. I have already given the references of Kautilya's Arthashastra, Mamidi Venkata Ramanaya's English translation. Everybody should read it, in fact, and then get the appropriate benefit out of it. Then, friends, we'll deal with the definition and meaning today. That is, banking basically means depositing money. This is the most important aspect. And depositing valuables for safe custody. And then with the banker, and the basic transactions have to be the withdrawal of money deposits and taking loans. So, banking consists of depositing money and withdrawal, and then taking loans also. Apart from that, keeping the goods in safe custody. This is the basic function of banking system. Then, of course, in the modern business of banking, the pledging of valuables, securities, then raising loans, short term, long term, these have all become an integral part of banking activity today. In the same way, cash credit facility, and then the banker's checks, and all these things, of course, subsequently followed. Then, actually, if you see how to find out the meaning and definition of, in the legal perspective, we should look at the law that deals with the particular subject matter so that the term could be defined in the context of that particular law only. And then that particular law is ultimately called the statute. So, what are the statutes here we'll have to see. Then the meaning of the term could be taken from the decisions of the higher courts like the High Courts and Supreme Court, which are called technically judicial precedents. Then we can also look at the juristic opinions of courts, men of letters opined on the subject matter, and finally the dictionary meaning also. We may also refer to the General Clauses Act 1897. General Clauses Act 1897 is a central legislation, and there are state General Clauses Acts also. And then under all these different statutes, the banking word, the banking has been defined. And then, as I told you, from courts and then juris also. The prima facie enactment happens to be the Banking Regulation Act 1949. I have given you references to certain statutes in my first lecture, and I asked you to get those particular bare acts, if you remember. I have asked you to purchase the Banking Regulation Act latest, the RBI Act, the Reserve Bank of India Act, the Securitization Act, the Recovery of Debts due to the recovery, that is DRT, the Debt Recovery Act due to banks, the Recovery of Debts due to banks enactment, and then the Bankers' Books Evidence Act, the Negotiable Instruments Act. These are all the most important acts. Invariably, Indian Contract Act applies, it goes without saying. So, friends, you had to get these particular books, as I told you, and I also told you to get the bare act from different students in groups, get from different publishers. You get from 4-5 publishers, different students, you can exchange. Then in the commentaries you will find then different case law also that will be beneficial to you. Then friends, I will now take you to the first definition under the Banking Regulation Act 1949 under section 5B of the Banking Regulation Act 1949. The word banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order or otherwise. What does it mean? The Banking Regulation Act says banking means first depositing. What for? For the purpose of giving them again as loans, putting them in investment. And the deposits are from the public, general public. Then they are repayable on demand or otherwise, and withdrawable by an instrument which is called check, draft, or order or otherwise. So friends, this implies certain characteristics. What are the characteristics then? Sorry. Number one, the first characteristic of the banking system under the Banking Regulation Act, Section 5B, is acceptance of deposits. So the purpose is acceptance of deposits of money. Then acceptance of deposit for what purpose? For the purpose of lending or investing. The banks can invest the money or can lend also. And if there is no intention to lend or invest, then it is not banking at all. So invariably, essentially, the banking business must consist of acceptance of deposits from the public with a view to lend them or invest them. Otherwise, how the banks will survive? They have to pay interest on our deposits. Then friends, further the explanation given under section 5C of the Act, if you look at bare Act 5C, that any company which is engaged in the manufacture of goods or carries on any trade and which accepts deposits of money from the public merely for the purpose of financing the business, as such, manufacturer or trader shall not be deemed to transact the business of banking. What does it mean? In course of business, company fixed deposits. We have already studied last year, last batch. Acceptance of fixed deposits. That will not come under banking business. That is for the purpose of financing the business. So that will not come under this particular category. It comes only when you accept it with a view to again invest, with a view to lend, then earn interest on that, then ultimately making it a regular affair with the public, only then that would be taken as a banking business. Then the third point is deposit of money. It means deposit of money only, that is legal tender currency by way of cash or check or demand draft, and nothing else, only money. It means money is the most important, primary most aspect. Then deposit of money from public, the fourth point, which means that the deposits could be made by any member of public and there is no restriction. It is for one and all. And a person here includes, the word person shows that, what does it mean? Means here the word person in fact implies that individual, a firm, a company, a cooperative society, a Hindu undivided family, and any juristic person, a body corporate, all these, in fact, individuals, institutions will come under the category of persons. Then friends, the next important thing, repayment. The money so received must be repaid on demand or otherwise, as per the terms and conditions of the deposits. The next point is withdrawal. The modus of withdrawal is either by way of check, draft, or as per the terms accepted by the parties at the time of making the deposits. which implies that the withdrawal should be as per the stipulated procedure of the banking system as has been made out. So, friends, with this background, what we understand is banking involves basically deposit of money from the public with an objective of lending it further, with an objective of, in fact, making it a business and lending it further, investing, and then it has to be returned also as on demand or even otherwise. Then how about safe deposit lockers? You had to now put a question. Banking system today involves multidimensional functions. We are talking of the banking definition originated as in the Banking Regulation Act 1949. Even in those days, banking system was used for overseas transactions and payment of instruments like bill of exchange and checks. However, today it is multidimensional. Bankers act as agents and they can deal with our accounts, shares, securities. So today the functions are multidimensional, and further the banking business today also consists of safe deposit locker, security purpose. So these are all the things which have to be taken into consideration, and of course the definition is concerned, I have analyzed it. If you say in general banking is concerned, you must add up that it also contains multidimensional functions including safe deposit lockers, acting as our agent, making payments on your behalf, and then purchasing securities on your behalf, and so on and so forth. And then today banking has got multi-dimensional functions beyond the definition given under the Banking Regulation Act. Now we will go further into the subject matter, dear friends, and then that this particular banking system is concerned, definition part is concerned. What are the other definitions? Dr. Herbert L. Hart, H-A-R-T. Dr. Herbert, H-E-R-B-E-T. L. Hart, H-A-R-T, Hart. He has written a book called Law of Banking. He defined banking by describing a banker as one who in the ordinary course of his business, the banker is one who in the ordinary course of his business honors checks drawn upon him by persons from and for whom he receives money on current accounts. This particular definition originated from the decision of the English court in Foley, F-O-L-E-Y versus Hill. Foley versus Hill, 1848, Volume 2, H.L.C., page 28. What it says is basically the banker is one who in the ordinary course of business honors checks drawn upon him by persons from and for whom he receives money on current accounts. It's purely a monetary transaction. Then friends, another book on banking law was written by Sir John Paget, P-A-G-E-T. I am giving the standard authors also, by the way. He observed, while commenting on the famous case of Birkbeck Building Society case, 1913, volume 29, TLR 219. He says that no person or body corporate or otherwise can be a banker who does not 1. Take deposit accounts, 2. Take current accounts, 3. Issue and pay checks, 4. Collect checks crossed and uncrossed for his customers. These functions are essential to be called as a banker. That's the reason why a corporate deposit, fixed deposit in a company, for example, does not carry these features, so that company is not taking banking business. That's the reason why that comes under the category of non-banking financial institution, if it is a financial institution. In routine way, the manufacturing industry or agency or any other industry takes fixed deposit. In routine, it is a loan, maybe secured or unsecured as the case may be, but it is not a banking business. We have to identify as to a question comes with regard to the parameters of the statute, whether the particular business carried is under the segmentation of banking. For that, essential is deposit and then withdrawal, and these are all the aspects which had taken into consideration. As we have seen, these are all the universal principles laid under this particular banking system. Now, friends, I will take you to Halsbury's Laws of England, 4th edition, Halsbury's Laws of England, 4th edition, volume 3, page 31. Halsbury defined the banking, identifying with banker as an individual, a partnership, or corporation whose sole predominating business is banking. Then, what is banking? Now he analyzes and states that the receipt of money on current or deposit account and the payment of checks drawn by and the collection of checks paid in by a customer. Again, it comes to same. Then, what is the essential thing here is, he was referring to individual, partnership, corporation, but remember today in India under the Banking Regulation Act, read with the RBI Act, a banking business can be carried by only a corporate entity, a registered company or a cooperative society. But there is no question of today partnerships or individuals carrying banking business. My dear friends, I am putting you a question. Maybe next week or the following week I will ask you back. Once we are back in our study room again, virtual, you study, find out and tell me whether banking business can be carried by individuals or partnerships. You examine as a research. You are going to submit research paper soon, next semester. Do that research now and tell me back as to whether a banking business can be carried by only corporates and cooperative societies or whether even individuals, partnership firms can carry this particular banking business. Very important question. I repeat, whether banking business can be carried by only corporations and companies and then the cooperative societies, or whether the banking business can be carried by individuals and partnership firms also. Study the RBI Act, study the Banking Regulation Act and come back to me on this. Now, provisions of Companies Act with regard to restriction on partnerships, etc. would not apply in this particular categorically, even though that provision is there. Even Halsbury's Laws of England says so, but in practice, this is my opinion. I may differ, you may differ. Let us examine, go for research and come back. Next week, when I come back to you, I put this question, you must be able to answer it. And your answers will be recorded and it will be put in YouTube also. Let it be used, for the benefit of one and all the viewers. Then, friends, I have given the definition of the statute under the Banking Regulation Act. I have given the definition of Herbert L. Hurd, Dr. Herbert L. Hurd. I have given the definition of John Peggott, Sir John Peggott. I have taken you to Halsbury's Laws of England. Now, friends, I will take you to a judgment, a decision of the Supreme Court of India. 2005, take down 2005, file, volume, F.C.S, Supreme Court Cases, page 122. 2005, volume 5, F.C.S, page 122. What are the names of the parties? Vimal Chandra Grover. Vimal Chandra Grover versus Bank of India. Vimal Chandra Grover versus Bank of India. The Supreme Court in this case quoted the definition given in the concise Oxford Dictionary on banking and stated that banking as business transactions of a bank only. Banking as business transactions of a bank. Business transactions of a agency is the particular subject matter of that agency. Maruti, agent of the Mitras, agent of Maruti. The business is agency of cars. What a bank is concerned, it is concerned with only the business of banking only, the transactions of bank. What are the transactions? Again, depositing, withdrawal, lending, investments, loans, safe deposit, lockers, and so on and so forth. This is how you have to work up on this particular subject matter. Then the Supreme Court further quoting the Black's Law Dictionary. Black's Law Dictionary. I repeat, Black's Law Dictionary. The Supreme Court said that banking is the business of banking as defined by law and custom. The business of banking as defined by law and custom consists in the issue of notes payable on demand intended to circulate as money when the banks are banks of issue, in receiving deposits payable on demand, in discounting commercial paper, making loans of money on collateral security, buying and selling bills of exchange, buying and selling bills of exchange, negotiating loans and dealing in negotiable securities issued by the government, state as well as the national governments and municipal and other corporations. The banks in India are governed by the Banking Regulation Act 1949. That's what I told you. The Supreme Court says so now. Under its clause B of section 5, banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft order or otherwise. So this definition covering in the multifarious act functions, the various aspects of banking system, and then from, in fact, even modern aspects are covered in this particular definition. That's the reason why I have brought it to you. Notice this particular judgment, decision of the Supreme Court, which is reported, and I have given you the citation. Also, in the definition part, in the examination point of view, all these things have to be made out clearly. So friends, in conclusion of this particular lecture on definition of banking, we can say that the Banking Regulation Act 1949 covers the concept of banking as such. The jurisprudence of banking, I repeat, the jurisprudence of banking is embedded in the provisions of the Banking Regulation Act 1949. That is the statute governing banking system in India happens to be basically the Banking Regulation Act read with then the RBI Act. The regulator for banking business in India is the Reserve Bank of India. We have seen earlier, the regulator for corporate company matters happens to be MCA, that is Ministry of Corporate Affairs. Dispute resolution, NCLT, then appellate tribunal, Supreme Court. Suppose it is case of banking, the regulator is RBI. The statute is the Banking Regulation Act. Then the dispute resolution, of course, there is no specific banking regulation tribunal except foreign exchange. There is a tribunal for disputes of foreign exchange. Then you had to go to high courts, then the Supreme Court. So the jurisprudence of banking is embedded in the Banking Regulation Act, and the scope of banking is expanded in the present commercial scenario by this Banking Regulation Act, in fact, and also other connected legislations which are narrated to you already, say, that is the SURFACE and then the debt recovery and then where Bankers Books Evidence Act and so on and so forth. Actually, under Section 7 of the Banking Regulation Act, every banking company must use as part of its name or, in fact, with business, the words bank, banker, banking or banking company. That's why you will find Andhra Bank, State Bank of India, Central Bank of India like that. No firm, individual or group of individuals for the purpose of carrying on any business use part of its or his name any word bank, banker, banking or banking company. Section 6 of the Banking Regulation Act, in fact, covers multifarious functions of the banking business, and the functions are not restricted to only acceptance of deposits, withdrawal, but it is multifarious. So, the banking business is expanded to multidimensional activities today, and then catering the needs of the present day society. Then, the definition and meaning of banking must be understood in the context of Section 5C and various other activities apart from B, that is Clause B of Section 5. And then, of course, you must also see the provisions under Section 7, 8, 9 and 19 along with Section 6 of the Banking Regulation Act to understand the banking jurisprudence properly. So, with this particular background, my dear friends, I conclude my discussion on this particular definition of banking, and then I will further go to the evolution and legislative history of banking in India in tomorrow's session. If not tomorrow, the following session, whenever we meet, we will be normally meeting on Friday and Saturday. So accordingly, we will see. And then, well, friends, thank you very much and good night. Goodbye.